Welcome to the January 31st session of the Phoenix Congress, where we are writing a blueprint for a better America. This legislative package will end poverty with universal basic income, end mass incarceration with major criminal justice reform, and end the endless wars by bringing our troops home and reducing our military budget. Today's session is the fifth of 21 public hearings on the 2022 legislative package, and we will review sections 120 through 131 today. The legislative provisions include ending the practice of civil asset forfeiture and establishing a national police misconduct registry. These sessions will alternate between Mondays and Thursdays at 1:30 p.m. Eastern through March 28th. For those following along at home, you can find a link to the legislative package in the description below or at bit.ly/B, A, lowercase Dropbox. If you'd like to submit a question in the chat, please indicate which of today's sections it applies to. And if you'd like to offer questions or other testimony for future hearings, please use the link in the description below. Before we get started, I'd like to go over, quickly read the preamble to the Constitution of the United States in order to set up or set the stage for what we're trying to achieve here. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. With that, I'd like to welcome the delegate from North Carolina's 4th District to continue his testimony on the blueprint for a better America.
Thank you, Mixed Chair. For the record, my name is Brian. I'm an organizer with the American Union and a Phoenix Congress delegate in good standing, representing what's expected to be North Carolina's 4th District in the 2022 election. And today we get to talk about federal civil asset forfeiture in section 120. You probably heard of horror stories about civil asset forfeiture. Here in North Carolina in 2014, the Department of Justice seized $107,000 from Lyndon McClellan, a convenience store owner who often deposited cash. And so depositing cash was suspicious. And so they seized his money, but he was lucky. A year later, they finally dropped the case and he got the money back. People aren't always so lucky. That same year, police seized thousands of dollars from a man who had just won the lottery. That good luck, though, got canceled out because even though he showed the receipts to the police, say, look, here's the $5,000 receipt from the money I just won. They took his money anyway. And eventually, after a year, they offered to give most of it back, and he agreed rather than try and sue them to get all of it back. Civil asset forfeiture is the process where law enforcement agencies take property, often cash or cars or things that are theoretically connected with crime, but they don't actually have to charge anyone with a crime in order to keep that property. This happens, billions of dollars get seized every single year, more than $2 billion by the Department of Justice in 2019. Now, there are many organizations that all agree that this is a policy that tramples on civil liberties. The Institute for Justice does a lot of work on trying to push back against civil asset forfeiture. This process has kind of always been around. Back in the early days, smugglers and things might have their property seized. They would just abandon property, but it really ramped up back in the 90s as part of the war on drugs. And if people who are accused of dealing drugs or whatever, if they had money, we created a financial incentive for state and federal police departments to go after and try and take that money. And once we created that incentive, they just kept doing it, and it's gotten bad. Wesley Hottot, who's a litigator for the Institute for Justice, he recently talked about a case where a man he'd moved, and he'd had his sister mail him his savings, nearly $9,000. And according to Hottot, when he offered to help the man recover his money, because he hadn't done anything wrong, the post office had seized his money. But the guy didn't want help. The guy said, look, I grew up as a black man in Alabama. My relationship with the government is very different than your relationship, and I don't want to get involved in this. To have to fight to maybe have a chance of getting your property back, this is a fight that many people just give up on. They just accept the fact that essentially they have been robbed and there's nothing they can be done about it. This happens all the time in courts, that he who has the most economic resources usually wins. And that's usually the government in cases like this. One of like many of the laws on the books, this one is colorblind on its face, but in practice, it doesn't work out that way. A 2015 study by the ACLU of Pennsylvania, they found that 63% of Philadelphia cash forfeitures involved money taken from black residents, who only made up 43% of the city's population. And of those seizures, more than 70% had cash forfeited without being convicted of a crime. In South Carolina, they determined that black men were 65% of all the citizens targeted for civil forfeitures, even though black men only make up 13% of the state's population. They also found that white people were twice as likely to get their money back. Of course, even if you do win and get your money back, you can still lose. In August of 2012, Mandrell Stewart, he was driving in Fairfax, Virginia, and the police pulled him over, and they detained Stewart and his girlfriend for 2 hours. They found 1/100th of a gram of marijuana and $17,000 in cash. Stewart explained he owned a restaurant. He was going to buy supplies for his restaurant, and the police handcuffed him, took him to police station. They didn't charge him, but they kept his money. It took him 14 months in a lawsuit to get that money back, but it was too late. He lost his restaurant, having all of his working capital confiscated by the police. We have to do better. We can do better, and we can fix it in the blueprint for a better America. There's been a couple attempts to address civil assets forfeiture over the years. In 2017, Rand Paul introduced the FAIR Act to increase the burden of proof, to make sure that you at least got a lawyer while trying to prove you should get your property back. And instead of letting the Department of Justice keep assets, giving it to the Treasury to try and discourage that for-profit motive from civil asset forfeiture. But that didn't go anywhere. But in 2020, Justin Amash introduced HR 8997 to end the practice of civil asset forfeiture. And so that's where most of the language from Section 120 comes from, is amending Chapter 942 of the United States Code, and Section 181. Section 981, that currently lays out all the procedures for civil asset forfeiture, is completely repealed and replaced instead with this one sentence: no person shall be required under the laws of the United States to forfeit to the United States any property, real or personal, pursuant to a civil forfeiture proceeding, including a non-judicial civil forfeiture proceeding. That's it. We're going to end the practice of civil asset forfeiture on the federal level. We have an opportunity to set a better example, and don't take people's stuff unless they've been convicted of a crime. The next subsection, or the next section in that chapter of law, deals with criminal asset forfeiture, and that's left alone. But the rest of the chapter is repealed. Criminal asset forfeiture, okay, if somebody committed a crime and then that's, you can take assets related to that. But outside of the criminal process, this will end the practice of civil asset forfeiture. Justin Amash's bill left in a bunch of stuff related to the drug war. Under the Blueprint for a Better America, the federal drug war will be ended, so it's no longer necessary. And that's why we end up repealing the remaining sections of Chapter 46. Civil asset forfeiture is not justice. So Section 120 is going to have the federal government lead by example. This is what the Fifth Amendment of the Constitution, this is supposed to protect against, where it says no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. And the defenders of this law can say, well, we wrote a law that says it's okay, so that's due process. And to which I say, we can and should repeal that law. With that, Mixed Chair, I think that concludes my testimony for Section 120, and I'd be happy to answer any questions.
Thank you. Fantastic. I am not seeing any questions. So seeing none, Section 120 is assigned to the Subcommittee on the George Floyd Justice Act. You may proceed to Section 121.
Thank you, Mixed Chair. Section 121 deals with state use of civil asset forfeiture. And like a lot of the provisions in here, there's restrictions as a piece of federal legislation on what we can do to tell the states what they can and can't do. But in this case, because the Fifth Amendment pretty clearly says that civil asset forfeiture is kind of repugnant to the Fifth Amendment. Section 121 includes a finding that Congress has the obligation to prohibit the use of civil asset forfeiture by the states. And so the way that Section 121 sets that up is setting out procedures to say that a person property can only be forfeited if there's a criminal conviction of a person for a violation of state criminal law, or there's been a civil proceeding that the state proves that the person has committed an offense, and the person who owns the property gets all the protections that are applicable to criminal defendants, including a trial by jury and the ability to be represented. So states can technically still use civil asset forfeiture under those limited circumstances. If they try to do it if they do it any other way, any person who's aggrieved by it is given the right to bring a federal cause of action in federal court to get relief, including return of the property and enforcement of those procedural protections. In Justin Amash's bill, he has a long list of findings, and while they're not included in the Blueprint for a Better America, I would like to read some of them just to sort of establish how Congress has the ability and the duty to end the practice of civil asset forfeiture. And so he wrote that Congress finds that the long-term failure of Congress, presidents, and the judiciary to recognize the illegitimacy of the government's civil asset forfeiture practices do not divest them of the authority to do so. The government cannot lawfully jettison the rights of the accused for the sake of convenience and profit. The early use of civil forfeiture in the United States was limited to admiralty and revenue contexts, in which the existence of a legal violation and the identity of the property used to effect it were often self-evident, and the owner of the property to be seized was often unobtainable. Although these limitations don't prevent those practices from being constitutionally infirm, they do materially distinguish the early practices for modern civil forfeiture. Modern civil use of forfeiture is not limited to admiralty or revenue contexts. Its reach extends far beyond property used to commit an offense and is often used to supplement rather than recover the government's revenues. The tortured status of civil forfeiture in current law, in which the fiction of the property as the defendant is sustained, yet the interests of property owners are, to a limited extent, nonetheless recognized, is the inevitable result of grandfathering civil forfeiture into a constitutional system that otherwise secures the rights of the accused. In a lot of the civil asset forfeiture is on the state level. And according to the Drug Policy Alliance, 80% of the time, there are no criminal charges filed when property is seized. And sometimes it's really abusive and even seems targeted. An armored car company, Imperial, recently filed suit just this month because in the last year, their armored car vehicles have been stopped. There's been no arrest. There's not even been traffic tickets, but more than $1 million in cash has been seized from their armored cars. And this is pretty, this is kind of like, this is highway robbery. And it's unrelated to this section, but the problem that these armored companies are solving, which is legal marijuana dispensaries who are prohibited from using the banking system and have lots and lots of cash from their customers. They're using armored cars to get the money, to move the money around. And so the Blueprint for Better America will solve that root problem by lifting the banking prohibition so that all legal businesses can use the banking system. A couple other things. The Supreme Court ruled in 2019 that they put an upper limit in some of these civil asset forfeiture cases. In the case of Tyson Timms versus Indiana, Timms he pled guilty to selling a few $100s worth of drugs, and then the state seized his $42,000 Land Rover that he bought from an inheritance after his father had passed. And the Supreme Court unanimously agreed that this was an excessive fine. Fining someone $42,000 for a few $100s worth of drug sales was excessive, prohibited by the Eighth Amendment, and the Supreme Court unanimously agreed that protection applied to the states. According to USA Today, since 2014, 36 states in the District of Columbia have taken steps to scale back their civil asset forfeiture. 4 of them have actually abolished it. And I guess I want to close with one more story. It's from last year, February 2021, and a man named Stephen Lara. He's a Marine. He served in Iraq and Afghanistan. He's a father, and when he was traveling from Texas to Nevada to visit his daughters, sometimes he takes his savings with him rather than leave his savings in his apartment at home. And so the Nevada Highway Patrol pulled him over for allegedly passing too close to a tanker truck. And I put a link to the video in the description below so you can see the body cam footage of the police. They're finding the money where Stephen told them it was, in his trunk. They're finding the $87,000 with the bank receipts accounting for it, and then just deciding, well, let's just take the money. Let's take his money and give it to the DEA so that they could get a share, and they did. And there's just something really Orwellian about how this is playing out, this guilt by suspicion, that you can just be you could be punished for this suspicion without due process of law. And if you watch that video, you'll see Stephen offering sympathy to these officers as they leave him on the side of the road with no money for gas to get home, no money to buy meals for his kids. He tells them, I know you're just doing your job. I know you're just doing your job. Well, if this is your job to take people's money on the side of the road, your job is wrong. we can fix that. We can build a better America that gets rid of that sort of work. We have the ability to stop this by unionizing as voters. And that's why addressing civil asset forfeiture is an essential part of building a better America. Next, Chair, I think that concludes my testimony for Section 121, and I'd be happy to answer any questions.
Thank you. Yes, I have a question that's actually related to civil asset forfeiture generally. So this applies to both sections 120 and sections 121. In most of these cases, you've been talking about seizing cash. You had mentioned an example where somebody's vehicle, personal vehicle, was seized. But when we talk about civil asset forfeiture, what is the range of what counts as a civil asset that could be seized?
It's pretty broad. It just needs to be sort of like connected to some sort of crime. For example, I forget what state it was. I think South Carolina. Guy in his RV, they found a couple ounces of marijuana. And so they seized the RV saying, well, that's the container that you were storing the marijuana in. So we're taking the container. And, and so he had to go fight to try and get his RV back. There was a report in Massachusetts recently looking at civil asset forfeiture. And in many cases, the very minor amounts of money that police are seizing, essentially, telling people to just turn over the money that they have on them and claiming it as forfeiture. In some cases, less than $1, literally taking the spare change from people's pockets and saying, oh, this is forfeit, but you can sue us to try and get it back. There's quite a large range. It also can be used against property. If you're perhaps if you're suspected of growing marijuana on your property, the law enforcement can try and seize that property. So civil asset forfeiture covers all sorts of property. If you dig into the existing statute that's being repealed, Section 981, there is a long laundry list, and it includes things like being accused of vehicle identification numbers. Like if you're accused of changing the vehicle identification number on a vehicle, then that is grounds for civil asset forfeiture. I hope does that kind of answer your question? It's very broad.
Yes, and so a follow-up would be, if I'm looking at amendments 4 and 5, that in theory should already cover this and say that without a warrant, we can't seize anything. Without just compensation, we can't seize anything. What is missing here? What is the link that has allowed this to become possible despite it seemingly not constitutional in the first place?
I'm sorry, I didn't catch your reference. You said you're looking at amendments 4 and 5
of the Constitution of the United States.
The Constitution. The Supreme Court has repeatedly and consistently upheld civil asset forfeiture and said this is constitutional because, again, due process of law. Congress wrote a law saying that it's okay to do this, and so that's due process. Which is why the solution, fighting this in court and everything is good and everything, but the real solution is to change the law, which we can do with this federal legislative package.
Thank you. Seeing no further questions, Section 121 is assigned to the Subcommittee on the George Floyd Justice Act. You may proceed to Section 122.
Section 131 and 132 are two parts. It's creating a national police misconduct registry, and so got some background information on this. In 2020, Donald Trump issued an executive order starting the process of collecting information, requiring the Attorney General to create a database for tracking police terminations, criminal convictions, civil judgments against law enforcement officers for excessive use of force, and start compiling this information. According to a poll taken in June of 2020, 82% of Americans supported establishing a national police misconduct registry, including 79% of Republicans and 88% of Democrats. One of the issues, though, is that under that executive order it wouldn't be a public database. So you and I would have no way of being able to know and be able to hold public officials publicly accountable for misconduct. And so what Section 131 does is establish, along those same lines, a publicly available registry that everyone would be able to access. There are some efforts to do this privately. Last May, the USC Safe Communities Institute announced a pilot rollout of the Law Enforcement Work Inquiry System Registry. You might that's what I forget what you call it, a backronym or whatever. So it spells out the Lewis Registry for former Congressman John Lewis. And it's an attempt to use open sources to create a comprehensive national catalog of police officers who've been terminated or resigned due to misconduct. And again, this is all good. The more transparency and accountability we have for law enforcement, for our public servants, the better. But we have the ability to address it on a national level by creating a formal registry. And I'm going to see if I can share my screen here and go into a little more of the details of what is in this. Let's see. All right. So in general, not later than May 25th of 2023, the Attorney General shall establish this misconduct registry. You'll probably recognize that date as the third anniversary of the death of George Floyd. And the contents of the registry will include complaints against law enforcement officers, depending on even acknowledging whether or not they were credible or not, whether they ended up resulting in disciplinary action, if they're pending review, whether or not they involved the use of force, and making sure that there's a record of complaints for which they were exonerated, that they were determined to be unfounded and not sustained. It's important to try and show the whole truth and not just a record of complaints. The registry would also include discipline records, termination records, records of certification in accordance with the next Section 132, records of lawsuits, and instances where an officer resigns or retires while under active investigation. So by bringing these things together into one federal registry, we make it publicly available for the public to see, to be able to search for individual law enforcement officers, especially those involving a use of force. And the initial funding for this program comes from unspent funds that, when we end the federal war on drugs, money that is earmarked for that can go to establish this misconduct registry instead. Yeah, so that's and then once again, it uses the same mechanism of withholding burn grant funds unless states submit their records for this registry. So I think that's pretty much it for this section. Next Chair, I think that concludes my testimony. And as always, I'm happy to answer any questions.
Thank you. I do not see any questions. So, Section 130 is assigned to the Subcommittee on the George Floyd Justice Act. You may proceed.
Thank you, Mr. Chair. Section 131, 132 is the certification requirements for hiring law enforcement officers. And this will require that states certify that let me do the screen sharing here again. That's probably easiest. All right. So the Attorney General will make rules for uniform reporting standards to certify that before police officers are hired, that they've completed the certification processes. And this ties back to the program, the misconduct registry established in the previous section. And yeah, I think it's pretty straightforward and self-explanatory. Again, using the same model of threatening to withhold burn grant funds if states don't go along with this. And I guess to demonstrate why this is important. It was in 2014, I believe, that the Cleveland police officer who shot and killed Tamir Rice. So a 12-year-old waving around a toy gun in a park. And the officer who shot and killed him had been let go from another department, but the Cleveland Police Department didn't look at the records that would have identified the issues that could have prevented the death of this preteen boy. And so by establishing a formal registry, a national registry, by requiring the states to check with the registry before hiring law enforcement, we can help prevent other deaths and avoid incidents like the one that killed Tamir Rice. I guess, and with that, Mr. Chair, I guess that concludes my testimony on this section, section 132, and I'd be happy to answer any questions.
Yes, I have a question that I think some folks may be interested in. Many police departments across the country are struggling to keep their forces staffed. That's happening where I live here in Austin right now. Could this make it more difficult for those departments to maintain the safety of their communities for that reason?
It's a good question. It is a real question. And I guess I would say that this section focuses on identifying officers who have a record of misconduct if they go to try and be hired by another police department. And so I guess to the extent that if it makes it harder for local police departments to hire officers who've committed misconduct elsewhere, then maybe that will avoid just as many problems as it creates. But I mean, you raised a larger issue, right? Is if you have a publicly searchable national police conduct registry, does that create a disincentive for people to want to be in law enforcement? And I think this whole legislative package goes to a larger issue of trying to rebuild America and our police as establishing justice and reforming and rebuilding the reputations of police departments. And one of the ways that we can do that is by ending, abusive practices like civil asset forfeiture, by ensuring that officers who've committed misconduct can't just leave and go somewhere else and get another job. And so by rebuilding the brand, by restoring faith in the police, I think you'll find more people that want to work, that really want to protect and serve as we get along in that process. But no, you're right. It is an important issue. I was reading something. I forget what I was reading this weekend. Looking at how when you do have police department staff levels falling, which ends up making the remaining officers work longer hours, working double shifts, that additional stress can then lead to, let's say, the use of poor judgment. And so there's a lot of issues. A lot of them are interconnected, and we can just try and solve as many of them as we can in one legislative package, and build a better America.
Thank you. Seeing no further questions, section 132 is assigned to the subcommittee on the George Floyd Justice Act. I'd like to thank the delegate for his testimony.
You're welcome. Sorry if those answers were kind of rambling. It's a big issue. I'm glad that we've made it through the whole George Floyd Justice Act, and looking forward to moving on to some of the other parts of the bill.
Fantastic. The next session of the Phoenix Congress will be held on Thursday, February 3rd. We will move on to subtitle B, the Weldon-Angelos Justice Act, relative to ending the federal war on drugs. This hearing is adjourned.